Breaking news! Artist sues company label for suing artist for writing his own songs. Sounds ridiculous, right? In the case of Fogerty versus Fantasy, it isn't. Musical artist John Fogerty sued Fantasy Records for previously suing him under the basis that he shouldn't have to pay the legal fees since he won the case. To understand this situation, we have to go back to the original case, Zanes versus Fogerty. John Fogerty, an artist famous in the 70s, wrote over 30 songs, but his most controversial song was The Old Man Down the Road, or rather, what the song sounded like. Fogerty used to be in Creedence Clearwater Revival, a rock band from the 60s, until he left in 1972. While in CCR, he helped write over 40 albums worth of music, including the song Run Through the Jungle. Fogerty may have written The Old Man Down the Road over 15 years later, but the rivalry between him and Saul Zanes, who used to own CCR's label and the copyright to their music, didn't fade in that time. Zanes claimed that Fogerty stole the melody and riffs of Run Through the Jungle and sued him for millions of dollars. The case didn't go on for long, however, because Fogerty went as far to bring his guitar into the courtroom. He played both songs back to back and proved to the jury that while the songs sounded similar, it was because he had written both songs. Of course they were going to sound the same. The judges decided that Fogerty was right and ruled the lawsuit void. However, Fogerty was now stuck with $1.9 million in attorney fees. Why? He won the lawsuit, and it wasn't even because of his attorney. Fogerty was pissed, and rightfully so. Not even a year later, he comes back at the Fantasy record label with full force, with the claim they should pay all of his legal fees. The Copyright Act of 1976 states that the winning party can make the losing party pay for their court fees, as long as the losing party's original claim was based on false and frivolous reasons. However, when Fogerty took the Fantasy to district court, the jury decided that Zanes was in the right and did not grant Fogerty his money back. Not deterred in the slightest, Fogerty filed for an appeal to move up to the higher courts, and when it was granted, he took his case to the Supreme Justices. Fogerty pleaded to the judges, and while there was no guitar playing involved, they were so moved that they created a precedent. Now, this case probably sounds like a fever dream. A songwriter getting sued for songs that sound too familiar, that songwriter countersuing the original prosecutor for making him pay money to his attorney. Trust me, it gets worse, but not until about 1996. For now, there is a moral to the story. A precedent is a previous case or legal decision that must be followed in subsequent and similar cases. A precedent defines the law in a new way, usually changing the meaning of the law altogether. And yes, a precedent was created in the decision of Fogerty versus Fantasy. Written by Chief Justice William Rehnquist, the decision on Fogerty versus Fantasy was that since Fogerty won the case, his legal fees should be paid off. The Copyright Act is meant to stimulate artistic creativity for the general public good. People who have been in copyright suits range from large corporations to small artists, meaning there is less of a need to provide an economic incentive to individuals in order for there to be adequate enforcement of the copyright law. Unlike civil suit cases, however, just because there isn't a need for financial reimbursements doesn't mean it shouldn't be available. The court decided that there would be a case-by-case decision about whether or not the fees should be paid off for the winning defendant, and they also decided that, in the case of Fogerty, he qualified for reimbursement. There was no dissenting opinion, only a concurrent. Justice Clarence Thomas, yes, the one who doesn't talk very often in court, believed that it was impossible to track just how much money was spent, and therefore the court should revert back to the decision made in Title VII of the Civil Rights Act. However, Thomas agreed with the majority opinion because he believed the previous decision of the court on Title VII was wrong. And now we have a precedent. Yes, those were plastic babies. All's well that ends well. Fogerty got his money and CCR got... well, I don't know what they got. But it's okay, because over the course of 1972 to 2015, there were over 10 different cases of John Fogerty and CCR butting heads. In 1972, CCR finally disbanded. In the 1980s, we had our lovely Saints versus Fogerty and Fogerty versus Fantasy debacle. In 1990, Tom Fogerty died of tuberculosis, and after his death, John Fogerty claimed he was mad at his brother for saying his manager was his favorite person. In January of 1993, John Fogerty refused to play with CCR when Bill Clinton was elected. Later in 1993, Fogerty refused again to play with CCR when they were inducted into the Rock and Roll Hall of Fame. In 1995, the two remaining members of CCR, Stu Cook and Doug Clifford, renamed the band Creedence Clearwater Revisited. In 1996, Fogerty sued the other members of said band for their name choice. However, in 2001, he dropped charges and was paid royalties. In 2011, Cook and Clifford stopped paying the royalties because Fogarty insulted their band publicly, which they claimed was a violation of the settlement. They also claimed Fogarty violated the trademark by advertising his concerts with albums by CCR. On December 8th of 2014, the bandmates filed a lawsuit against Fogarty for said advertising. They claimed Fogarty had been previously threatening many lawsuits and they refused to be bullied, which is why they filed against him. In 2014, Fogarty said in an interview that he got through his anger. A final end to all these lawsuits? Nope. In 2015, Fogarty filed a countersuit against Cook and Clifford because of the royalties they hadn't been paying him. He also claimed they were violating the agreement by playing on their own under the name Creedence Clearwater Revisited. Will the madness ever end? Maybe when they're dead. But at least now you know how the Fogarty versus Fantasy case went down, how you create a legal precedent, and why you should never be in a band with John Fogerty.